That was nice.
Good morning, everyone. I will now call to order the November 2nd, 2022 Clackamas County Board of Commissioners Land Use Hearing. I will note all commissioners are present. Please rise for the Pledge of Allegiance. I pledge allegiance to the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, and liberty and justice for all. Thank you. Good morning, everyone. We are holding this meeting in person and virtually. If you've joined us via Zoom for this meeting and are interested in providing public comment, we will prompt you regarding how to do that when the time is right. Today, we will consider ZDO-273, a proposed legislative text amendment to the Clackamas County Zoning and Development Ordinance related to the allowance of short-term rentals in certain areas of unincorporated Clackamas County. This matter is on remand from the Oregon Land Use Board of Appeals. General public comment will be taken at the usual allotted time. As always, the public is welcome to sign up to testify. For those attending in person, please fill out a blue card right over here on the desk and put it in the basket, and Tony will pick it up, and you will be called to testify at the appropriate time. When you are called on, be sure to include your name and the area where you live. I would like to remind all participants, including staff, all elected officials, and members of the public, that Robert's Rules of Orders will be enforced in this meeting. We welcome your opinions and look forward to your polite participation. The hearing on ZDO 273 will proceed as follows. Number one, we will first hear a presentation from Principal Planner Martha Fritzie. I want to also note County Counsel Nate Boderman is sitting next to her. And over here on the right is Tony Mayernick, our county clerk, who will be assisting in this meeting. We will next open the hearing for public testimony, beginning with public officials who will have 5 minutes each. Then representatives from recognized community planning organizations and agencies will have 3 minutes each. Finally, others wishing to testify will have 3 minutes each. The board will then deliberate and either render a decision today or set a time to make a decision at a later date. Assisting us in the hearing is our clerk, Tony Mayernick, planner Martha Fritzie, and Assistant County Counsel Nate Boderman. Does anyone or any commissioner have clarifying questions at this time? See none. Please make your presentation.
Oh, it's down there. Good morning, Commissioners. I am Martha Fritzie with the county's Planning and Zoning Division. And we are here today, as the chair mentioned, to talk about, can consider a proposal under ZDO 273 on remand related to zoning code amendments and the allowance of short-term rentals in Clackamas County. The proposal also addresses a remand from the Land Use Board of Appeals, or LUBA. I think it's important before we start talking and thinking about this is to understand what this proposal is not doing today. And so many of you recall, and members of the public, if you're listening, the county's been working on short-term allowances and regulations for several years. And back in 2020, had adopted essentially a two-part program. The first part was some regulations and a registration program into the county code. And the second part were some zoning code amendments to allow for short-term rentals. Now, the regulations related to licensing that were in the county code were never funded, never became effective, and have subsequently been repealed by this board. And so that program is not what's under discussion today. This discussion today is simply about the amendments to the Zoning and Development Ordinance related to allowing for short-term rentals. Excuse me. And so why do we even need these ZDO amendments? Well, there's a couple of reasons. So first of all, our Zoning and Development Ordinance doesn't specifically allow for short-term rentals. And from a zoning perspective, that means that they are generally not considered an allowed use in a dwelling in most zones. And furthermore, our zoning code specifically prohibits the use of a guest house as a source of rental income, so it could not be used as a short-term rental. We know that there's as many as 1,000 short-term rentals operating in unincorporated Clackamas County. At least those are the numbers we had back when we started this project in about 2019. And a number of them are paying transient room tax. And so there's sort of this awkward inconsistency and confusion around allowances in our zoning code. And so part of this project originally was to make it clear where and how short-term rentals are allowed in the zoning code. And so I said we did adopt amendments, and that's true. We adopted amendments to our zoning code to allow for short-term rentals generally in every dwelling in the county. That decision, however, was appealed to LUBA by two parties. In January of this year, LUBA issued a decision that sent back or remanded all or parts of 5 of those assignments of error that had been identified in the appeal. Subsequent to that remand, the county and actually one of the parties who had originally appealed our decision appealed the LUBA decision further to the Oregon Court of Appeals. The Oregon Court of Appeals in June of this year affirmed LUBA's decision on remand, and so essentially said to the county, LUBA was correct to send this back to you for these items, and you need to address these items to remedy the situation. This is kind of how we have gotten to where we are today. So we had some code amendments. We have been told that they were not okay by LUBA, and they've sent them back. And so to address these assignments of error in the remand, it has caused, well, there's really 2 pieces to this. One is that we have had to sort of rewrite and restructure the code amendments from the way they were into the way now that they are in the proposal in front of you, which includes adding a definition of short-term rental in our definitions section. That definition is found in your packet, and it essentially defines a short-term rental as the rental of a dwelling unit, portion of a dwelling unit, or guest house for overnight residential purposes for a period of up to 30 consecutive nights. Overnight occupancy of the dwelling unit plus any guest house shall not exceed 15 persons, which is the same as for the regular residential occupancy of a single-family dwelling. A short-term rental may include use of accessory structures such as decks or swimming pools that are located on the same lot as the dwelling unit or guest house being rented. So that is the new proposed definition of a short-term rental. And one of the things that LUBA made pretty clear is that this short-term rental is indeed a separate use. And so it has caused us to have to add this use into the various zoning districts as where it can be allowed. And so the proposal adds short-term rental as an outright allowed use in dwellings and guest houses in all of the zoning districts where dwellings and/or guest houses are allowed, with the exception of farm and forest zones, and I can talk a little bit about that in just a minute. There's also an exception in urban and rural reserves. The reason for that is over a decade ago, we went through the county and metro and all the metropolitan area counties went through a process to adopt urban and rural reserves around the Portland metropolitan area. As part of that process, there is some stipulations under state law that prohibit counties from making code amendments or amendments to their plan that allow for new uses that were not allowed at the time the reserves were adopted. And so effectively, we cannot amend our code to allow new uses in urban and rural reserves. And so therefore, because this short-term rental is a new use, we can't allow it in the urban and rural reserves. So we did have to make that exception also. And then finally, the last piece of the code amendments is to specify that a guest house can be used as a short-term rental. Currently, rental of a guest house at all is not allowed, and so the amendments make it clear that we are talking about just the short-term rental of a guest house. We did not broaden that because that wasn't what had been approved before, and that wasn't something that was discussed by the board previously. So that's a lot of words for saying we are addressing each of the sort of three sets of assignments of error from the remand. And the first set being this, the finding or decision by LUBA that the amendments that the county had made were not consistent with state law regulating farm and forest lands, and that short-term rental is not an allowed use under the state laws that essentially dictate what can and cannot be allowed on farm and forest lands. And so that essentially means that our EFU, ag forest, and TBR, the exclusive farm use, ag forest, and timber zones, which are the county's farm and forest zones, cannot outright allow short-term rentals because it is not a use that is specifically identified as one that we can allow under state law. And so as part of this, I mentioned that LUBA clearly identifies a short-term rental as a separate use. And so we had to restructure our amendments to make sure that short-term rentals were not an outright allowed use in those farm and forest zones. And I'll talk about some alternatives potentially in those zones in just a minute. The second assignment of error really ties into the first and essentially said that our amendments didn't comply with statewide planning goals 3 and 4, which are agriculture and forest lands, and didn't comply with our own the county's comprehensive plan policies related to agriculture and forest lands by not allowing short-term rentals in the zones that implement statewide planning goals 3 and 4, and also our own ag and forest lands. That eliminates the conflict there, and so that assignment of error is addressed. And so the last piece of this, so the first piece was essentially that we cannot allow short-term rentals as an outright allowed use in farm and forest zones. The second part is this one assignment of error that LUBA found or agreed with one of the petitioners that the county had not adequately addressed affordable housing policies in their own comprehensive plan. And so there were 2 policies that were specifically called out that hadn't been adequately addressed. And so this is really just a findings issue. And so the proposed remedy for this is to write more and or better findings. And those are found in the staff report in the longer staff report that was included in your packet. I think it starts on page 25, if I remember correctly, of your packet. And, you know, of course, it's not quite that simple because between the time that we originally adopted the code amendments for short-term rentals and now, we have actually completely rewritten Chapter 6, of our comprehensive plan, which contains the affordable housing policies, and that was done through ZDO 282, which was phase 2 of the land use housing strategies project, where we talked about middle housing. So those policies have been amended. They are similar to what they used to be, and so in the findings, we address the new policies. And those policies essentially relate to encouraging and allowing more affordable housing by allowing a variety of housing densities and price ranges, and allowing for rental units with a variety of size, location, and accessibility. And so there's a couple things that needed to be addressed related to short-term rentals. First and foremost is that those policies don't necessarily directly relate to short-term rentals. You know, you all have adopted a number of changes to our zoning code that more directly address those policies by allowing higher densities in certain areas, reducing parking ratios for certain residential developments, adding middle housing. And so there are a number of things that the county is doing that would directly affect those policies. And so I don't think anything with allowing short-term rentals would necessarily affect all of those efforts that the board has recently made and is continuing to make to affect affordable housing and allow for more places and more variety of affordable housing. And so there, of course, are a lot more words in the findings, and I'm happy to answer any other questions about those. But we did provide some more detailed findings to address that final assignment of error. So, as we are considering this, there are a couple of significant issues or other considerations to think about. One, I said I would circle back to potential other paths in EFU, TBR, and ag forest, but this also would apply to properties in urban reserves or rural reserves. And that's, LUBA didn't really go down the road of saying that short-term rentals could not possibly be run as a home occupation. And so currently, the county allows for home occupations in all of those zones. And there are a set of standards that home occupations have to meet. There's a land use application they have to apply for, notice to the neighbors, staff decision, and that decision would be good for 3 years. And so there is still that opportunity in zones where short-term rentals are not allowed outright. I think that, to be fair, I should note that a lot of short-term rentals might not meet the home occupation criteria, but some of them could, and there are also exceptions to the home occupation. You know, one of the most notable criteria is that the operator has to live in the dwelling, but of course, there's not a specific definition of that. So there may be some opportunities that would work for some people under the home occupation. And then finally, there in the recent several months, it's come to staff's attention that there are some other platforms out there, including one who provided testimony named Swimply, that allow for a property owner to post, similar to Airbnb, home amenities on an hourly rental basis: swimming pools, play structures, tennis courts, recreational facilities on their properties. And there is a specific request in the testimony that you've received that the short-term rental definition be broadened to allow for something like this. And so this is not anything that was contemplated throughout the whole several 3-ish year-long process of considering short-term rentals. And in fact, the definition has always included the word night, and LUBA in their decision has identified the short-term rentals as overnight rentals. And so it was always intended to mean an overnight rental between 1 and 30 nights. With that said, allowing for hourly rentals of home amenities, like through a short-term rental, through the definition of short-term rental, is certainly something that the board can do. That's not what staff has proposed in their definition. The board could do that. Can say that staff feels that certainly more public outreach would have to be done around this issue, because it is not something that was contemplated and not something that was discussed or intended at the time. But if the board wanted to make an amendment today, we could make a motion to approve with an amendment like that. We could certainly do that. There are potentially other options, again, for people who want to do this, either under a home occupation, like currently. It would, in most cases, especially if there have outdoor recreational amenities, would involve an exception to the home occupation, because home occupations are supposed to be primarily conducted indoors. But some facilities might be able to do that. There's also a home occupation to host events. It has come to our attention that some of these rentals are indeed doing what we would consider hosting events, having pool parties for 40, 50 people. So we do have an allowance for that under our home occupations, and we also have an allowance for conditional use as a recreational facility. So there are potentially other land use routes that somebody could go currently to allow for the hourly rental of home amenities. All would require land use applications, notice to neighbors, decision, things like that, and potentially hearings. And so that is, again, I'm happy to answer some more questions about that, but that is something that was included in your testimony with a specific request for a change. And then Finally, staff recommends approval of ZDO 273 on remand as drafted. And again, that draft includes the definition that includes overnight in the definition of a short-term rental. And these proposed amendments would provide the certainty to future and existing homeowners that our zoning code currently does not, and also address all of the issues on remand by LUBA. And so before I open this up for questions, I did want to bring to your attention that we received one more piece of testimony this morning that was emailed to you shortly before the hearing. Tony has printed copies. It's only 2 sentences, or maybe one. It is a request from a member of the public for the board to leave the record open for 7 days so he can provide additional testimony. And I'm going to hand it off to Nate to explain to you what your options are related to that.
Thank you, Nate. Please continue. Thank you, Principal Planner Martha Fritzie. Nate Boderman, County Counsel.
Good morning. So there are certain land use hearings in which you are required to leave the record open or to continue the hearing. This is not one of those. This is a legislative procedure, and so any request to leave the record open or to continue the hearing is just that. It's a request. It's not a mandate, and so it's up to the board whether that's something you want to entertain at this time. And if you do want to entertain it, you have options. Again, you can leave the record open for written testimony. You can continue the hearing for additional oral testimony. But I just wanted to be clear because there are some instances in which you are required to leave the record open at the request of, or a similar request. This is not one of those instances.
Okay, regarding leaving this hearing open, I don't think any testimony we would receive would alter the findings from the Court of Appeals, who has directed us to take this action. Secondly, it's going to be difficult to have all 5 board members here between now and we recess in December. Tony, as we're speaking, look at the calendar. Text me if you have any dates available. But I'm going to tell you, Commissioners, November is virtually impossible to get this done. Staff has worked very hard for us to go ahead on this. While I appreciate this gentleman who wants us to have an additional 7 days, he could have put his comments in an email and I would have read them into the record.
And this individual has submitted testimony previously that
And I
should
think
be
we
in your
saw
packet.
that we saw that in an email, and
Just to
it's gone
clarify.
to the commissioners' emails. I'm pretty certain. If any commissioner wants to address that particular email from this individual, more than happy to. So, staff presentation, you're finished for now?
Yes.
We are going to entertain questions and comments from commissioners. Commissioner Savas, you're up.
Yeah, so thank you for your presentation. I just have a few things I want to confirm. So essentially, the remand, basically the state's saying you've got a 15-person limit on STRs.
No, the remand was really related to the allowances in the farm and forest zones. And so currently, we have a 15-person limit in a dwelling. And so we wanted to be clear that that applied also to a short-term rental in a dwelling, or if you're short-term rentaling, which is probably not the right word, a guest house, the 15-person limit counts for both combined. So we just wanted to be clear about that.
Okay.
That
So-
nothing about allowing a short-term rental changes any of that.
So if someone has a 20-bedroom home and they have the means to accommodate safely, 30 people, let's just say, this would impose upon that.
I don't think building codes allows someone to have a 20-bedroom home. I think it becomes something different at that point.
Was that right?
Yes.
So what is the threshold?
Ooh, is it? Oh, look, Cheryl's here.
Cheryl Bell, please come forward.
I wasn't aware of that.
Yeah, it is interesting. Cheryl, please come forward, introduce yourself and your position, and please, can you answer the question?
Good morning, Commissioners and Chair Smith. It's Cheryl Bell, Assistant Director of Development for the Department of Transportation and Development. There is a definition in the building code of what changes a dwelling. I am going to admit, it's been a while since I've been in that part of the building code, so I can look it up and get it to you. But it is a definition of how you classify the building. It goes from a residential construction to commercial construction, and then you're looking at congregate living. And that's where that definition changes. So it's a much higher requirement of building. You have different fire codes, different exiting. Our typical residential home that you'll see used for an STR wouldn't meet that definition.
It's what?
A typical residential home that you'd see rented for a short-term rental would be a typical dwelling, would have that under 15.
Under 15.
Yeah, 15 and under would be.
Are
the limit.
15 bedrooms allowed?
I'm going to have to look.
Somebody
Usually,
look
it's usually part and
it up.
parcel also with the land use planning, because the land use will say 15 is the limit for a dwelling. So that pairs with the building code requirements. You could have 15 rooms, but they may not all be 15 bedrooms. So you could have a rec room, your kitchen, your media room, things like that.
So, we certainly know of properties in Clackamas County that have more than 10 bedrooms, right? And I don't think they're really considered anything other than homes.
Yes.
So I'd like
Jennifer
some.
Hughes, Senior Planner, would you like to take a stab at this?
Good morning. So I think we need to obviously keep this distinction between the building code and the zoning code. And I think the key issue with the zoning code piece is that the county caps occupancy of a single-family dwelling at 15 and has for 30-plus years. That's the standard. We never proposed through the 3-year project to allow short-term rentals to have more occupancy than any other single-family dwelling would have. Technically, we don't have a cap on the number of bedrooms, so you could conceivably have, a 20-bedroom home if you could get a septic system for it or fit it on a lot, with sewer or whatnot. That would be extremely unusual, but it could theoretically happen. But it doesn't change the occupancy. It's 15. And it's this idea behind sort of defining what constitutes a family, and there was a lot of work done before my time about fair housing and restricting sort of like who can live together, that the county shouldn't be controlling that. And so the cap that was put was 15 is reasonable. After that, you're talking about something that really isn't just a dwelling unit anymore. So it's not that the county's bound by that. You could change it if you wanted to, but it was never contemplated that we would be having more people staying in a short-term rental than a regular dwelling. In fact, originally, the county code regulations would have capped potentially the occupancy at lower than 15 through those business regulations. So
Business rate.
I didn't-
Go ahead.
I didn't realize we were opening up a can of worms, but well, we can
Yeah.
cap that for now. I'll leave that alone. The other thing I wanted to get a better understanding around, and I think Martha, you touched on, I'm not sure. So this urban reserves being, I'm going to call it frozen in time, so to speak, that once it was established as urban reserves, so you can't really introduce anything new, I guess, sounds like. So, and did you touch on that with regard to, when you said affordable housing, would that apply similarly to HB 2001, for example?
So that would have, except that HB 2001 only applied inside the urban growth boundary on properties with urban services. So all the reserves are outside.
Okay,
It didn't become an issue at that point.
all right. All right, I think that gets to my questions. Thank you.
Thank you, Commissioner Scholl.
Yes, good morning, and thank you for all that good information. I want to clarify a couple definitions. One, a guest house. Now, that's a place on a residential property that's used for guests, obviously, but is not rented out, correct?
Currently, a guest house, under our zoning code regulations, currently a guest house cannot be used as a source of rental income, is what it says.
Good, okay. And a home occupation would be in that same house where somebody is renting a room or part of the house for a long term. Is that correct?
Well, a home occupation can be a number of things. A home occupation could be any sort of commercial business that would fit the standards. So we often see them for like a hairdresser who wants to have a little salon in their house. A home occupation is really an allowance for somebody who lives in a dwelling to run a very small business out of their dwelling.
And both the guest house and the home occupation are allowable in EFU, ag, forestry, and timber, correct?
No. The home occupation is allowed. Guest houses are not allowed in those zoning districts. Those guest houses are only allowed in certain residential zoning districts, urban residential, rural residential.
Okay, one more question, just to make sure we understand this. So somebody who's got a home that happens to be in exclusive farm use, correct? Okay. And they have, they cannot use, a room over the garage as a guest house. Okay.
So a guest house is a separate structure on the property. There are limits to size. It can't be larger than 600 square feet. It doesn't have a full kitchen. So it's not actually a separate dwelling or house, despite the name. It is really just sort of a detached room or a couple of rooms that are guest quarters. So we would not authorize a permit to build one of those over a garage in EFU unless it was somehow connected to the house and actually part of the single-family dwelling.
Okay, thank you.
To follow up on the guest house in natural resource zones, could somebody apply for a conditional use permit and have a guest home in this natural resource zone? Why?
Because the state law is very explicit on what can and cannot be allowed in the natural resource zones and the farm and forest zones, and guest houses are not an allowed use.
Not even in a conditional use. I'm
Well-
talking not an allowed use, I'm talking a conditional use. There's a definition in law.
Yes, so conditional uses are allowed in all zones, but there is a list of certain types of uses that can be allowed under a conditional use permit. And guest houses are not one of those things that can be allowed under a conditional use permit.
Thank you for clarifying that. Now, can a guest house in the allowed uses areas can be used as a mother-in-law flat or a granny flat?
So technically, a guest house has to be used by guests or a member of the family. There isn't anything that says that a member of the family couldn't live in a guest house, but it is not a separate dwelling. It doesn't have a separate full kitchen. And so the person living there is still part of the family and using some of the same facilities in the single-family dwelling.
You say a guest house cannot have a kitchen, can it
Right.
have a bathroom?
Yes.
Okay, good. Good point of clarification. Commissioner Savas makes a really good point about the urban reserves and the rural reserves are absolutely frozen in time. I understand that's not to be taken up in this particular hearing, but I do think that is worth noting for future considerations as we move along that particular timeline of the urban growth boundary issue. Questions for any other commissioners before I open up the public hearing?
Just one.
Yes, Commissioner Savas?
Maybe Nate can answer this one. So I'm just going to assume that getting back to this 15 person or 15 occupants, and it states that we can assume that it applies to STR. So anyone who's advertising a 20 person STR on Airbnb or any of those, basically is really in violation of our ordinances currently.
Yeah, so our definition, is synced to the definition of dwelling, but that is explicitly limited to 15 overnight guests, right?
Okay.
And so, if there's advertising for events, that's a whole other separate issue, right? But if, as long as they're limited to the 15 overnight guests, that comports with our definition.
Okay. And then I'm going to switch gears slightly and ask almost the same question, but that when I brought up let's say the 10-bedroom home, safely, let's say 2 people per bedroom, that's 20 people, that exceeds 15. If they're overnight and it's not an STR, it's simply a residence, they have the 10 bedrooms, even though there's a 15-person occupancy. Whether it's a party or a family gathering for Christmas or whatever it might be, technically they're in violation if they have an overnight, 15 people stay in that home overnight.
Technically, yes.
Okay.
Yeah, I mean, it's a sticky wicket, right? I mean, is that an enforceable violation? I don't know, but it doesn't meet the definition, so
Oh, you
yes.
know, huh?
Yeah, okay. Thank you. That's all I have.
Yeah, it is. Commissioner Fisher.
Yeah, thank you, Chair Smith. So I've been trying to dig in a little deeper to Dennis Teikla's submitted testimony since he's not here due to illness and he wanted to testify, and I'm just wanting to make sure, I don't know if you can help interpret it for me, because it's his exhibit. It's Exhibit 7 of the packet. So he is recommending that the BCC table any legislation that will legitimize STRs at this time without any way to regulate it for all the associated adverse impacts. And then he goes on in a lot of different ways. But I just want to make sure I'm understanding the premise of why we're here today, and this is to really incorporate what LUBA has directed us to do into our zoning. This isn't about regulations. Even what the zoning ordinance are that they direct us, that we're trying to accommodate that ruling, isn't regulating. Or just help me understand this in context, if you can.
So I think the point he's making is that there is some desire for members of the public, and you've heard this in your associated proceedings, right, with the county code amendments that were recently repealed. Those contained the regulations on the registration and certain restrictions related to the operation of short-term rentals specifically. I think the point he's making is that, I think that good policy would dictate that you adopt something to regulate the short-term rentals simply because all you're doing through zoning amendments is saying whether they're allowed or not allowed. It says nothing to, parking or noise or any of those, associated impacts that people have been testifying about, again, in the other proceedings. The reason that we had 2 tracks is because that's what the board directed us to do early on in the process. And LUBA said that was okay, that we could regulate those differently. We didn't have to regulate everything through the zoning code, and so we chose to make very limited directed amendments to the zoning to simply allow these in the zones that they're now allowed. We chose to use the county code to regulate those other aspects, and of course, that was a whole separate process, and that's, proceeding on a separate track.
Yes, and our process today is taking LUBA's ruling and incorporating that into our zoning code. And if we chose not to do that, then we would go back to where we were before, where short-term rentals are not an allowed use. Is that right?
Correct, if you don't do anything today.
Okay. If we don't adopt this.
Or
And then the
if you don't
consequence
adopt
of
it,
that would be that we wouldn't be, if they're not allowed use, then there's questions about the TRT tax and all those other ramifications.
Yeah, I mean, the practical effect of not adopting this as part of the zoning code is that they're prohibited. That short-term rentals, the use of a dwelling as a short-term rental would not be allowed under our zoning code.
And then that would be subject to code enforcement or any other complaints by neighbors that were concerned because they're not allowed use.
Correct, it'd be a
Okay.
zoning violation.
Okay, thank you.
Thank you for reading the gentleman's concerns into the record. I appreciate that.
Yeah, Chair Smith, I just want to say I did not really read them into the record. They're extensive, but since he wanted
They
to.
are into the record. They have been in the packet.
Oh, right.
Yeah.
But, so I didn't read them. I
Highlighted.
just, because he wanted to testify and he's not able to, I just wanted to take a little deeper dive into what his position was.
So quick question, if we fail to adhere and pass LUBA's findings who've been directed from the Oregon Court of Appeals, is there a penalty? What happens to us?
No, there's no state mandate that you allow short-term rentals at all.
No, that's not my question, Nate. My question is if we do not adopt the findings, as presented by staff in your recommended motion. If we don't do any of that today, and this board decides, oh, we're not going to pay attention to LUBA, we're not going to pay attention to the Court of Appeals, which I do not favor, what happens to us?
So because this is on remand, there is no effective zoning code amendment, right? And so our zoning code is as if you had never adopted the short-term rental provisions in the first place. So there's nothing in our zoning code currently that's effective. So if you don't do anything today, it remains, that there remains no authorization for short-term rentals.
I understand that. You still have not answered my question, and maybe you don't know the answer. If you don't know the answer, please say it. Do we incur a penalty? Does anybody know? Jennifer, please come forward.
Do we have to address
No,
that? Is the question? No. We don't have to
There
do
is.
anything. But if we don't do anything, then our zoning code continues to prohibit short-term rentals. But nothing happens to the county if we don't send this back to LUBA and address the remand.
Well, I find that interesting that the Oregon Court of Appeals has weighed in on instructing LUBA to instruct us to do something, but if we don't,
They told us what we can't do. And basically, by sending it back, they've negated everything you did. So right now, the code's fine. They're fine with it. What they were saying is, you can't do this, and we're sending it back to you in case you want to do something different. And we're here today to say, would you like to do something different?
but what they said is, according to state law, STRs are not allowed in natural resource zones.
Correct.
We have to adopt that part.
Our code doesn't allow them now.
Okay,
because-
but they
right.
exist.
Well, right, they're not legal under the
Okay,
zoning code
So
currently.
by adopting that today, what happens to these rentals, the short-term rentals, who are in those zones?
They remain non-compliant with the zoning code as they are currently. So they are
Okay.
already in violation, they will continue to be in violation unless they apply for a home occupation permit, which may or may not be successful.
And then what is the county's action with that?
Complaint-driven code enforcement.
All
So
right.
if a neighbor complains, we pursue it. We currently are only prioritizing situations where there's more than 15 occupants, and the other ones are low-priority violations. I will tell you, just somewhat related to this, there's been discussion at the AOC planning directors about trying to pursue some kind of state law fix for this. I have no idea whether that will be successful, but there are certainly other counties who feel that this should be changed. But it's not in the county's control. We can advocate, but the state legislature has to act.
Thank you, Jennifer. Commissioner Savas?
Yeah, so I'm going to summarize what I think I understand and just tell me if I'm wrong. So because of the action that we took in trying to legitimize, legalize STRs, they replied back and say, well, yes, but no. And the no's are, we know what they are. So we could actually do nothing today and bring this back a year from now or 6 months from now and take action. Until that time, STRs are illegal.
That's correct.
Right, STRs are illegal. And essentially.
Illegal. They're illegal.
Illegal.
Yes,
Yeah, they're illegal.
that's correct.
And essentially, if we adopt it today, then the state has said, you can, yes, you can. By default, they legitimize STRs by default, but taking our action, but not in certain zones as you already specified.
Correct. And what the state, I think, technically said, and Nate can tell me if I have this wrong, but they said you can do this everywhere except natural resource zones. They didn't speak to urban and rural reserves because that wasn't an issue raised in the appeal, but because of what they said and the way they said it, we can't allow them in reserves. But they also said you can do it in these other zones, assuming you can make better findings about your affordable housing policies in your comprehensive plan. And that I would describe as more of a technicality, not to say that affordable housing isn't important, but they didn't say you couldn't do it. They just said you've got to address these policies better. And so that's what Martha has done in the staff report, is a very robust analysis of why this is okay. So could there be another appeal on those grounds? Sure. Somebody could still say, we still don't think, but the courts have clearly said short-term rentals in zones other than farm and forest, yes, we can do that. Again, assuming it's consistent with our comp plan.
Right, so there's a last question. So there's nothing, by adopting this today, there's nothing that prohibits us from, I don't know if time, place, and manner is the right word, but is it the right word?
Sure,
Okay.
I like that.
Okay.
Yes.
So let's just say it's time, place, and manner. We can dictate anything. We can dictate you can only have short-term rentals on one day a week if we wanted to,
Yes,
essentially.
that's correct.
All right? So
Thank you.
there's no limits by adopting this on how we do
If you were to
STRs.
I guess there's a nuance here. If you were to subsequently adopt business regulations, which is what you did before, and then repealed, and I know it certainly could come back, that's, we believe, fine. If you were to come in later and do something in the zoning code that regulates short-term rentals differently than just saying they're an allowed use, there are some issues with that regarding notice, regarding non-conforming uses, and et cetera. So I think that business regulations would still be the appropriate mechanism for doing that. But you could do zoning code regulations later if you wanted to.
Well, the part that bothers me a little bit is the swimming pool example you all used, right? So that's not an overnight stay, probably not subject to the TRT, certainly not, in the definition of an STR, but it concerns me because it's a business activity. And you said that comes under home occupation more so than it does under STR.
Well, that would be how it would work based upon what our proposal is today. If the board was interested in allowing for short-term rental of home amenities by the hour, I don't see anything in the Court of Appeals and LUBA decisions that would prevent you from doing that. What staff's concern is that there's been no outreach about that. There might be different impacts. And if you were to simply do that today, what it means is somebody can do that with no notice to neighbors, no opportunity to appeal. It just happens. And so we have some concerns about just doing that because it feels sort of outside the project. But there's not something that would prevent you from doing that in the same zones that you're talking about doing short-term rentals.
Okay, thank you.
Thank you. Before we go to the other commissioners, thank you, Tony, for raising this screen. It has quite the odor to it. Commissioner Fisher, you're up.
So there is an option of deferring all of this until I know that Paul and Mark, Commissioner Savas, Commissioner Scholl are working on looking at our previous regulations, maybe adjusting them, adding to them, and bringing back a proposal. Would there be any detriment for us doing that today?
There is no timeline to respond to the remand, but again, the practical effect is that short-term rentals would continue to be not allowed in the county anywhere.
But right now, they're not allowed.
Right now, they're not allowed.
So
And
it would just be a matter of, at the point of adopting a comprehensive policy, which would, I don't know, I think that might be a reasonable way to go. What do you guys think?
I'm thinking that we need to adopt the policy and be legal, is what I'm thinking. But that's just me.
So Nate, answer this, is it not legal for us to defer? Like Chair Smith says, she wants to be legal to adopt the policy. Will we be doing something not legal by deferring until we have a
No, I mean,
comprehensive?
again, there is no mandated timeline in which we need to respond. The option to defer or to not adopt anything at all is a perfectly
But
legal.
if we don't adopt this today, short-term rentals remain not legal.
Correct.
And when I say I want to be legal, I want the short-term rentals to be
Got it.
legal. And then at another date, I believe, when we have lots of time for consideration, to adopt additional findings on possibly how to regulate and/or tax them. Does that make sense?
Makes more sense, thank you.
Okay, thank you. Commissioner Scholl and then Commissioner Schrader.
Well, I sure do like land use hearings. I'd like to thank Mr. Dennis Talca for his testimony today. And for the people listening to this hearing, I know it's very confusing, but I believe that the adoption of the LUBA decision into our Clackamas County zoning code will not affect the short-term regulations which this board is working on and intends to finalize in the near future. I therefore agree with the recommendations of the staff regarding the approval of ZDO 273. That's where I'm at. I'd like to get this legal, and I want people who are listening today to make sure they understand that this is not, we're not dealing with the short-term regulations that Commissioner Savas and I are dealing with.
Okay. Thank you. One more commissioner testimony, and then I do need to open this up to a public hearing. Go ahead,
Right,
Commissioner
So
Schrader.
that was not a motion yet. I do
No.
agree. Again, I really appreciate what Commissioner Schull said. That's kind of the way I'm feeling about this. We have two commissioners who are looking at regulatory structures. One of the issues we've had with regulation is the cost and where that would land and how we would manage that. And that is the sticky wicket that we are dealing with in an era of constrained budgets. It's not because we don't think that there has to be some regulatory oversight. It's going to need to be funded, and to do it prematurely would give people false hope that there would be, in my mind, oversight when there wouldn't be really any oversight or any ability to have oversight. So I really appreciate what my two colleagues are doing with this. I think it's a better way to go. I trust your judgment, both of you, to manage this and move forward with it. Thank you.
Okay.
Yeah, there you go.
Commissioners, any further comments we can hold till later? I will now open the public testimony of this item, beginning with public officials. Are there any public officials online or in the room who wish to testify? See none. Are there any representatives from any CPOs or agencies that wish to testify? You will have 3 minutes each. In the room and/or online, Tony?
Not at the moment, Madam Chair.
Okay. Is there anybody in the room who submitted a blue card or not that would like to testify on this today? See none. Tony, I'm going to have you moderate the public communication on Zoom. Do we have anybody on Zoom who wishes to testify today?
Madam Chair, there are a number of hands raised. I will call on them in the order received. If you would like to testify, please use the raise hand feature, and you will be added to the list. I will begin with Andrew Mulkey. Andrew, please state your name and area of residence. You will have 3 minutes.
Hello, my name is Andrew Mulkey. I am testifying here today on behalf of 1,000 Friends of Oregon.
Can you turn it up, please?
Yes, Madam Chair.
All right, does it help if I speak louder?
Yes,
Yes,
Andrew.
Okay, all right, I will try and speak like this. My name is Andrew Mulkey. I'm testifying here today on behalf of 1,000 Friends of Oregon. My address is 133 Southwest 2nd Avenue, Suite 201, Portland, Oregon, 97204. And I was listening to this hearing and jumping up and down in my seat when Ms. Fritzie and the other planners and also the Board of Commissioners were talking about occupancy and whether or not a dwelling can be occupied on a temporary basis by 15 people. And I believe the answer is no. And so I believe there's a problem with the short-term rental use as the county has defined it here in this new definition that it introduced on remand. And the reason for that is because of Oregon's structural specialty codes. And I think the staff tried to address that, but I would like to provide a little bit more clarification on how I think those codes are interpreted and applied. And the long and short of it is that occupancy limits for a building that is defined as a dwelling under the specialty code is different than an occupancy limit that would apply to a building that provides temporary or short-term, whatever you want to call it, transient overnight lodging. And that is what a short-term rental is designed to do. And so the occupancy limit for permanent residence in a dwelling is different than the occupancy limit for a dwelling that provides temporary overnight lodging. And that's shown actually in the design criteria that need to apply to such a structure in the Oregon specialty or structural specialty codes. And so basically, a building that provides transient occupancy is subject to occupancy design group R3, which is a residential design group R3. Whereas long-term occupancy, such as you would have what you're thinking of in a dwelling, is subject to occupancy limit R1. And so the R1 group does include some types of transient occupancy. However, it defines it as a lodging house, which I think would apply to a house that's providing short-term rentals. And it says the limits are 5 bedrooms or total occupancy by 10 people. So those limits exceed what the county has written in its definition of short-term rental. And I think that the definition of short-term rental also conflicts with the definition of hotel in the code. And so by allowing short-term rentals in dwellings, I think the county is essentially turning those dwellings into hotels. So anyway, I'll wrap up, but I strongly urge the Board of Commissioners to consider this and actually delay adopting the proposed amendments here on remand. And I agree with the staff that there's no requirement, because this is legislative, that the county adopt an amendment on remand. The prior amendments that the county adopted are no longer in effect and do not apply. So I think this is something that deserves a little bit more consideration and a little bit more tinkering. And so
Thank you
what I
very
would
much,
ask
Andrew. Thank you very
the
much.
board
You've made your point, and you are out of time. Before Nate and Martha, a point of clarification. What he said is totally contrary to everything that we've heard today about the allowances of 15 people. Correct me if I'm wrong, but wasn't it Thousand Friends of Oregon, one of the plaintiffs on the case to the Oregon Court of Appeals?
That is correct. They were one of the petitioners.
So if he wanted that point clarified, he should have done so when they had the opportunity to present to the Oregon Court of Appeals. Am I right or wrong?
That would have been an issue that
Should
could
have
been
done
brought
that.
up.
So for him to come in and say at the 11th and a half hour that we can't have 15 people, would you address that, please?
Well, this is an issue apparently highlighting a potential conflict between zoning ordinances and building codes, and I'm not sure. I know we have our building official here in the room. He can probably speak to the specifics of what the building code may or may not require. Frankly, this isn't something I don't think we've vetted. This is the first time we've heard of this particular issue, so
So your point of clarification is we are adopting zoning amendments. We are not adopting building codes. As the caller says, the structural specialty code would fall under the building codes. We are doing zone amendments, correct?
we are, but we certainly have an interest in making sure that those
Yeah, but
don't
we're not
conflict.
going to do that today under this. We're not going to send it back and redo everything today on our building codes. And can you address, again, the 15 people?
So again, I can't address building code requirements, but our zoning code currently allows up to 15 related or unrelated people to live in a dwelling. It's the definition of a family. And so the intent was in allowing short-term rentals, to not allow more than that, to not do anything that is inconsistent with what we consider as the allowed number of people in a dwelling.
I agree with everything Nate and Martha just said, and then I want to add a little bit to it,
Please
which
do.
is there are already circumstances where the building code and the zoning code, I mean, they don't have to be entirely in sync. We try to avoid conflicts, but the fact that we say, for example, you can have 15 people in a single-family dwelling, like all the time, long-term rental, that's our standard. If it's what we would think of as adult foster care, I think there's a different name for that under state licensing now, but the idea that you're providing care and you have all these rooms, there are times where the building code, and Matt can speak to this, Matt Rozelle, our building official, requires a higher level of construction for those, and the zoning code still says it's a single-family dwelling. So by doing this, it does not mean that someone does not have to comply with the building code. Of course they do. It's completely separate. We should be messaging that if it turns out that they are going to have a short-term rental for 15 people, and it means that they need different exiting or different fire, then we need to be providing that public service for people. But it does not mean that you cannot do this with a 15-person limit in the zoning code. The zoning code not only does not regulate building codes, it's not allowed to. So they are completely separate. And this just becomes this issue of public, we need to provide good public service and tell people, you need an extra exit or a different, window size, and I'm making all that up, but
But
Matt
that's
can
not what
speak to it.
we are not considering building codes today.
That is
We are
correct.
considering zoning.
That is correct.
Thank you. Commissioner Savas, are you okay?
I got my question answered.
Okay, Commissioner Fisher.
So I'm just curious, if there's a requirement that a dwelling has a limit of 10, and we say people, you can't have more than 15, but wouldn't the reasoning be the same, that a dwelling is constructed to accommodate 10 people? I mean, isn't there consistency here?
Well,
Well, the way,
Or shouldn't there be consistency? I mean, isn't it for the same goal, for safety, for ingress, egress?
Well, it is, and I think what Jennifer was saying is that the zoning code considers something a dwelling. What specific codes you have to build that dwelling to is up to the building codes. And they may have different standards based on how many rooms or how many bedrooms. It may require different construction, something different with the construction, more exits, different windows, et cetera. But it doesn't mean it's not still a dwelling. She's much more articulate than me, generally.
No, I mean, I'm looking at, like, kind of trying to figure out the bigger picture here from a policy perspective, is when does it make sense to have consistency and when does it make sense to diverge? But if the goal is safety in construction and safety in living in or utilizing a structure, it seems like them being consistent would be good policy. So I'm just trying to figure out the reasoning why I don't know why we allow 15 in this and not 10 per the residential dwelling code.
Cheryl Bell, and please introduce yourself and you too, whoever wants to talk today.
Hello, I'm Matt Rizal. I'm the Building Codes Official or Building Codes Administrator for the county.
Thank you, Matt. Do you have a comment you'd like to make?
Well, I think I can start a little bit, and then I brought the expert because, like I said, it's been a while since it's been in the building code. Commissioner Fisher, the point that you brought up is confusing to a lot of people. We have two standards of codes. We have a residential structural specialty code and a structural specialty code. They sound like one should be only houses and one should be only commercial. There is a mix between the two. So the safety issue is, Jennifer said it very well. The land use defines what that dwelling is and that occupancy. Then you come to the building code, and depending on the structure, we will look and see which code applies and apply those standards based on the actual physical space. So we often work across those codes for different structures. For example, if you design a very fancy house, you will need to go into the commercial code for the structural provisions, even though it's still a residential home. So we're very used to working across those codes. That's not a safety issue.
And Matt, would you like to opine?
I think she explained it well. The tricky thing is short-term rentals aren't really contemplated in the building codes.
They're not.
You have your R3, which is 1 and 2 family dwellings, and then you have your R1, which is more of a hotel. We're trying to tie these in, but there's not a specific code for short-term rentals. Does that make sense?
There's not a building code for short-term rentals.
Well, there's not a specific code. We kind of have to, as Cheryl was saying, we're trying to intertwine.
It's just a
these two.
residential building code that for health, safety, welfare, and all that.
And short-term rentals are typically built under the R3 residential code.
Okay, thank you. Are you finished, Commissioner?
Yeah, I think my only last remaining question is if R3 residential codes, and that's one we're using for short-term rentals, and those are built with occupancy of 10, where do we get the 15?
So that's kind of where these collide a little bit. they define in the Oregon Structural Specialty Code that you can have up to 10 congregate living in that structure, or and also transient. So the definition of congregate and transient isn't really addressed in the short-term rental. Yeah, I think we'd need to look into that further and address that.
There's not a clear code analysis, and especially based off of the testimony, we want a little bit of information to do a code analysis. But it's difficult because, and then it becomes really, it comes into the stuff that Matt and I talk about a lot. It's nuancy things. It's like, well, you can build it using this code for all of it except this one piece. It gets very down into individual pieces of construction. So it's not quite as simple as a straightforward, this is the
Yes.
occupancy, this is the code. The mix across the two codes is very common.
Thank you. Okay, we're going to move on. Tony, is there anybody else online who wishes to testify?
Yes, Madam Chair. Next, I will call on Cameron Kilberg. Cameron, please state your name and area of residence. You will have 3 minutes.
Hi, I'm Cameron Kilberg with Swimply. I'm sorry, I actually reside on the East Coast, but it's a nationwide company. On behalf of Swimply, I'm testifying to support the continued adoption of short-term rentals and the inclusion of home amenity rentals in Clackamas County. Swimply is a home amenity rental platform which allows homeowners to share underutilized portions of their home with their neighbors. While Swimply has started with the sharing swimming pools, all underutilized spaces, which are not sleeping quarters, can be shared, be it your yard for a dog to run, an art studio, or sharing your garage for someone to tinker on their car. We're an extension of short-term rentals in the home sharing economy. The county has made numerous arguments trying to differentiate home amenity rentals from short-term rentals, which I address in my written testimony, but today I'll address key portions of the county staff's written comments. First, home amenity rentals are stated to be a likely home occupation. However, the county staff has admitted to Swimply Host that it's unlikely a home occupation license would be granted because each license has an almost zero noise allowance. This is ironic because for a short-term rental, there are no restrictions to use the home, and the staff have gone out of their way to clarify that outdoor use is allowed and welcome with no equally applied limitations. Second, home amenity rentals are misrepresented to be event venues. The county staff have referred to home amenity sharing with the purpose for hosting events. Home amenity rentals are not commercial entities hosting events. Rather, they are residential in nature with guests enjoying the amenity in question. Just as with short-term rentals, the amenities of the home are used in the same capacity as the home was intended to be used. Third, the county has clarified home amenity usage, but has no rational basis for restricting the term of the rental. The county staff definition addresses the use of home amenities, with the most recent draft even specifically calling out swimming pool usage, but states that the home must be rented for an overnight stay. This is quite frankly irrational. When you rent a home, you by default have access to the home's amenities, and therefore this need not be stated. Thus, the implication is that the county is acknowledging home amenity sharing, but with no rational basis restricting it to one platform versus another. Furthermore, the county itself has admitted in the original zoning ordinance that there are simply no restrictions that specifies a minimum time for rental in state or county code. Finally, the county staff has argued that home amenity rentals have not previously been acknowledged and thus should not be addressed at this time. We believe this is short-sighted. Home amenity rental is part of the home sharing economy and currently functions within the short-term rental market. Restricting home amenity rentals will not remove the activity, and they will continue to operate under the short-term rental allowances. A quick search on Airbnb can show you hundreds of local homes with a variety of amenities, including pools and spas, and Airbnb itself has made it easier to find homes with amazing pools, creative spaces, chef kitchens, and even grand pianos. Airbnb has also put out commercial advertising to use its platform to find an amazing pool. It is impossible to know if Airbnb guests are staying for a handful of hours or overnight to use these advertised amenities. As long as the home would be listed on a platform deemed a short-term rental platform, these rentals would be allowed. In summary, we hope that home amenity rentals should be treated equally to short-term rentals, and there's no rational basis to why the latter is given leeway where the former is restricted. We believe they both serve a purpose. They help offset costs for homeowners, they help families afford the rising costs of day-to-day living, and they ensure equitable access to resources.
Thank you very much, Cameron. You have exceeded your 3 minutes. I think we understand what you're saying. If you'd like to stay online, I'm going to ask staff if they would like to opine on some of her comments of Cameron Kilberg from the East Coast.
Well, I mean, I hope that I had articulated all of this earlier. I guess I would just restate that, that staff has noted in both the written and the presented material that many of these would not actually comply with our home occupation standards, but some of them might, and they could potentially go through a home occupation with an exception. There are other opportunities because some of these are indeed hosting events. I never meant to imply that they all were considering hosting events. But some are, and we do have an allowance for home occupation to host events that allows for multiple events per week and even per day. And finally, the last option would be to go through a conditional use permit for some sort of private recreational facility. And all of those options are there. And so I just wanted to be clear, and I hope I was clear earlier. Just wanted to clarify that, I suppose. And just finally, the comment that in the definition that the last clause does not need to be stated, that's fine, and it in fact does not need to be stated. The intent in putting that last clause related to being able to share home amenities or have access to home amenities was intended to clarify. And so if that's not something that the board wants in there, they could certainly strike that last sentence in the definition of short-term rental. And so I guess that's all I would say at this point.
Commissioner Savas.
Yeah. I struggle with all of this in the larger sense, just speaking more holistically, that, the commercialization of residential neighborhoods has been a concern of mine. And with that said, I did hear her also mention, if someone wants to rent a Airbnb or a short-term rental overnight, knowing it has a swimming pool, for example, that there's no time limit. I mean, they can rent it, pay the TRT, and do all those things, and just, leave at 7 o'clock at night, for example, right? No one's gonna know the difference. And perhaps that's something that people can do. But I don't see how we can really regulate that per se. If they're gonna pay the full freight for an overnight rental, and pay the market rate for it and use the amenities, then I guess there's perhaps when the regulations are all set, when we do that in the future, then great, if everything complies. But I'm gonna ask the question a little bit differently. If let's say the home has a occupancy limit of 15 as an STR, and they have a party in the daytime and 50 people come over, is that violating the occupancy, knowing it's not an overnight stay?
No, similar to if you or I owned a house with a pool and we had, 50 of our closest friends come over for a party. That would be fine, because it's just a one-off type thing.
Right, so it's really up to the agreement with the property owner or the STR operator to say there shall be no more than X people on the property at any one time. That's their method of controlling it. And if we have in the future an STR limit of how many people can use the property, we can still do that in the future as well.
Yes.
Okay, thank you.
Okay, commissioners and people online, we've been here for an hour and 15 minutes. One commissioner needs to leave at 11:30. I will call for a motion, further discussion in 5 minutes, unless there's somebody else online.
Madam Chair, at the moment, Brittany Colton would like to testify. Brittany, please state your name and area of residence. You will have 3 minutes.
Good morning, Commissioners. My name is Brittany Colton. I'm a resident and property owner in unincorporated Clackamas County. I was born and raised here and have lived in the county on and off for over 40 years. We submitted written testimony, and I ask that you please consider that in addition to the brief testimony that follows. A year ago, we put in an in-ground swimming pool. It's fully permitted with the county. It's connected to our home via deck and also a downstairs studio apartment. Shortly after we put it in, we learned of Swimply. Actually saw a news piece on Good Morning America about a family in West Lynn, also in unincorporated Clackamas County, who had been renting their pool for over a year. They were the #1 pool rental in the entire country and have been for 3 years now. We looked into it, consulted our insurance broker, and decided to give it a try. Immediately, we were bombarded with reservation requests. There was clearly a need and demand in the community for this service. It never occurred to us that this was a use that was not allowed. We certainly knew that Airbnbs operated all over the county, and you can rent pools just by themselves on that site. The fact that our pool rental was on a different platform seemed inconsequential. Just to give you a flavor of where our home is located, we are at a dead-end street that leads to 2 driveways, one of them being ours. We have 7 acres, pool is in the backyard, no vehicles park on the street. You can't see the backyard from the street or the neighborhood. Most of our guests are families coming to enjoy a quiet swim or to celebrate their child's birthday. We are home during all of these visits. The only difference between us and a traditional Airbnb, and this is important, is that our guests primarily use just a home amenity instead of the home and the amenities. This really is a distinction without the difference. In the 3 years that Swimply has been operating in Oregon, which is one of its top locations, tens of thousands of residents and visitors have enjoyed this service. This is something your constituents want. Swimply has offered very simple and modest text amendments to expressly make it an allowed code use. If you don't approve this, Swimply isn't going away. The demand isn't going away. Pool companies are 2 years out for new construction, and many of these homeowners are putting in their pool with the primary purpose of renting it out. If you do not approve text amendments to allow for this use, you will find yourself in the exact same position you are today with Airbnb, trying to rein in a use that has been rampant for years. You have the opportunity now to try and catch this use at the front end and address it. And by addressing it, you should find a way to allow this use to continue because it is clearly one that the community wants. There is no reason to put these hosts through a heightened regulatory requirement that you are not requiring of your Airbnb hosts. Finally, we noticed that since we have been in discussions with the planning department, they have amended the code provision to expressly exclude this use, trying to say that renting a house's pool for an afternoon is qualitatively different and more impactful than renting a house with a pool and staying overnight for days or even weeks.
Thank you, Brittany. I'm going to
Okay.
give staff an opportunity to address the very last comment she made.
About expressly prohibiting it?
Yeah, is staff working on something to expressly prohibit?
No,
Renting
what,
of
what
amenities.
she's referring to is the wording of the definition of short-term rental that's proposed in your packet that makes it clear that a short-term rental is for overnight stays and not the hourly rental of home amenities.
Okay, so, thank you for that. Tony, anybody else?
If there's anyone else who would like to testify, please use the raise hand feature, and I will call on you in the order received. Madam Chair, at this time, there are no hands raised.
Thank you. I will now close the public testimony part of this hearing, and is there any further discussion on this? Commissioner Savas.
Chair, I'm going to cast this out here so that we can understand what we're about to do in a different sense. So
Sure.
if we act today and we approve this, we are, so to speak, opening the floodgates, if you will, for STRs, and now they're legal. And then we come back later, we put restrictions on that, then we're narrowing it back down, right? Then we're impeding people's freedom, so to speak. It would seem to me that it would be much easier for us, whether you want to look at it politically, you want to look at it from a regulatory standpoint, you want to look at it for anyone who's perhaps making investments on their properties. And of course, the last commenter who spoke just raised that very issue. It seems to me that we ought to be very thoughtful that we don't, again, open up the floodgates and then somehow constrict it later on. It would seem to me that would be far more difficult than it would be to be very careful and thoughtful and open up the floodgates only as much as we choose to do with our regulations.
Okay,
And
thank
being
you very
there's no
much.
time, being there's no urgency to do this, I'm probably likely to just vote no today on this, actually.
We can amend the motion, Commissioner Savas. There's another commissioner, and I know other people would like to opine on this. Commissioner Fisher.
I just want to make sure that the home occupation option would allow utilizing your home for hourly rental of a swim situation.
It would, in all likelihood, require a home occupation exception because of the outdoor
Okay, but
nature.
there's a process in place.
There may be a
to do this.
process. I can't guarantee that they all would qualify.
Okay, so that's good. Yeah, so this has been really interesting. And I would have to say that I agree with Commissioner Savas that we should do this all comprehensive and inclusive of the regulations. Along with this, And I think that the community out there is asking for clarity, and when it comes to livability and quality of life and commercialization of neighborhoods, but also balancing that with tourism and the need to economic development, recovering from the pandemic. There are all these issues combining the, both actions I think are good, and it would also put some sort of pedal to the metal of getting a proposal to this board sooner than later on regulations. I think that the research is out there, the information is there. I know that Commissioner Scholl and Commissioner Savas have been working hard, talking with folks and coming up with ideas, and there isn't a reason why we can't do this soon. We could even put a timeline on it as to, I don't want to put a timeline on Commissioner Savas, but you and Commissioner Scholl would know.
Well,
and then we could best communicate to the public relations through PGA what's going on, and that would be beneficial.
And I will have some remarks regarding that. Commissioner Scholl, you're up.
Mr. Boderman, you are our legal counsel here this morning. Here's a what if for you. What if we move to deny the ZDO today in thinking about moving it into next year, because it's going to be next year, at the same time that we meet to discuss new STR regulations. If we were to hold off on this until then, are there any legal repercussions that we might suffer in the next, say, 90 days?
No legal repercussions, as far as I understand. I mean, there are no penalties, as Chair Smith was asking about previously. Again, the practical effect is that short-term rentals would not be a legal authorized use in Clackamas County.
That's a problem.
And so we could coordinate those efforts to the
So
extent.
Commissioners, I'm going to interrupt here as chair. And this is a problem that we have had with this ever since I became chair. The last commission had problems with this for 4 years. Now we're going on 6 years and unable to make a decision whether we want to have short-term rentals legal or not. And that's how I'm looking at this. Now, if this board wants to pass this and then take out the hourly amenities and just exclude those and just let them go like this, but I think that we do need to move forward and make sure short-term rentals legal, because I believe they're constitutional. And unless some other grand poobah decision comes down that says, oh, every single county in Oregon cannot have a short-term rental, I do think it's incumbent upon us to make the current short-term rentals the practice that's being currently conducted, that this board has not been able to make a decision on thus far, to make them legal. Now, we are not going to address this soon, this year, or even within 90 days. Because, Commissioners, as I keep saying, and it's falling on deaf ears, I need 5 commissioners here at one time to do that. Many commissioners are traveling and have other outside duties. And the work sessions on this will be tremendous. And looking forward, I don't see how we're going to be able to do this without Commissioner Scholl and Commissioner Savas saying, oh, we want to bring in this regulation and this tax, and we're going to do this. We're not going to get anywhere. Today is our opportunity to move forward. And I, as chair, am not going to be running to put this back on the agenda within many months. Today, you make your decision. You either make short-term rentals legal or not, and you affirm the higher court's decision that short-term rentals are not allowed in natural resource zones, and those are the questions before you today. Now, the callers were very good on trying to confuse us. Oh, I want to rent my swimming pool. I want to rent my tennis court. Blah, blah, blah. Well, that really isn't for us to consider today. I believe that use will continue, regardless of what this board does today. So with that in mind, I'm going to allow 30 seconds rebuttal from Commissioner Savas and Commissioner Sonia, and I will entertain a motion. Savas, you're up.
So Nate, really quick, my question is, Commissioner Scholl's question was, say no to this today or versus deferring it. Is there really a difference between the two?
No,
Okay.
there's no practical difference.
Okay, so my statement is this. The lady's example of, geez, I'm not really renting the home, I'm renting the pool, and they're separate. Well, I would say that you couldn't build the pool without building the home in a residential area. So that gets back to my point about the commercialization of neighborhoods and trying to get this right. I don't see a big deal, frankly, of getting this done all in one fell swoop. I think that we're somewhat have the option. We don't need to piecemeal this, but I don't think it's fair to say, by the way, it's all legal, do what you want, and then come back later and then say, oh, no, we're going to do it this way. That I think is really not, is somewhat of an injustice for folks.
Thank you very much, Commissioner Fisher.
Yeah, so my position is that I'm in agreement with Commissioner Savas that we should do this at one time. The commercialization of neighborhoods needs to be addressed with regulations. And I don't think if we defer this for 90 days, as Commissioner Scholl had suggested, because it's the status quo right now. We're just continuing the status quo for 90 days. And Chair Smith, I appreciate that you are the chair and you are determining agenda and figuring out how to prioritize and what's important and working with the vice chair on doing that. But I'm also aware that two commissioners are able to bring something and bring forward and put on an agenda. And I do believe that this board would be willing to spend some Wednesday mornings addressing the suggestions that Commissioner Scholl and Commissioner Savas are going to bring forward. And I have confidence in their ability to bring us something that will consider what we will agree to.
Just a point of clarification on two commissioners bringing something forward. Yes, any two commissioners can, but staff has to be ready to answer all the 1,000 questions that this board wants to do. You just don't put something on the agenda, people, and automatically think it's going to happen. So there's a lot of staff preparation and time. If you don't believe me, talk to our county administrator, Gary Schmidt. Commissioner Schrader, you're up.
Yeah, folks, I have to leave. I'm meeting with Senator Merkley, touring our affordable housing units that we've been redeveloping. So I'm going to make a motion because I just think we need to put this to bed. From my perspective, this is a very narrow decision, and I've done land use for a very long time, okay? And I've worked with our folks here for a very long time. My concern is you'll be putting people in a position that they're already going to be doing this. It's going to be illegal. There's no enforcement out there. The problem we're having with this whole piece anyway is from the other folks that feel differently is that, there is no enforcement. We're trying to figure out how to pay for the enforcement. And I know that's what Commissioner Scholl and Commissioner Savas are working on. I think right now it's time to just fish or cut bait. I'm ready to make a motion. Staff has been working on this it must be your nightmares at night, okay, to come back to short-term rentals. I get that. It's my nightmare at night, among other nightmares. But in any case, I am going to move that we recommend approval of the amendments for ZDO 273 on remand as drafted. People will not be illegal, and this, as far as I'm concerned, we are committed to working on a regulatory structure, and I will do everything I can to move that forward with my colleagues. Thank you. Do I have a second on a motion?
Seconded.
Okay.
Motion has been made by Commissioner Schrader to approve ZDO-273 as recommended by staff. And I will say this. We need to make legal a current practice that's already being conducted in this county. We don't have time to go through and, about hourly rentals for a swimming pool today. That's not the crux of what this hearing is about. I'm fully willing to entertain a hearing that deals with all the issues that we've been dealing with, but yet I've yet to see a proposal by any commissioner any commissioner that wants, where's your proposal? You got to put it in writing. What's staff's proposal to help us regulate this? We've addressed this time and time again. I do encourage a yes vote to make this practice legal based on the Court of Appeals decision regarding natural resource zones. Tony, please call the poll.
Commissioner Fisher,
No.
Commissioner Scholl,
Aye.
Commissioner Schrader,
Aye.
Commissioner Savas,
No.
Chair Smith.
Aye, motion passes 3-2. Commissioners, 3-2. I want to thank all of your comments. All of them are worthy of consideration. I do not want any commissioner to feel that you were not heard today. Yes, you were. Bring a proposal in writing, and yes, we will consider that when we can get it scheduled. Thank you all. Thank you, staff. Thank you, people, for calling in. What else?
One more direction on
Did
your
I
script.
not follow my
Yes.
staff
Yes,
report?
At the end, go ahead and direct us to draft an
It
ordinance
has
to
been moved.
implement.
Okay, hang on a minute. Now that the proposal has been approved, I will direct staff to draft an ordinance reflecting this decision included on the agenda for the board's adoption at a future business meeting. Correct. Thank you for keeping me legal. Yes, commissioners, I'm serious about, bring forth what you need to do on this. Just because we pass this today doesn't mean we can't continue with this area that has been in the making for at least 6 years. Seeing no further business before this commission, we are adjourned.